Well, I'd like to thank everyone for coming to today's lecture. This is the Peter Allan Memorial Lecture in Public Law. It is my great pleasure to introduce Professor Richard Fallon, the Story Professor of Law at Harvard Law School and affiliate professor at the Government Department at Harvard as well. An introduction, well, let me first say a bit about the Peter Allan Lecture. The Peter Allan Memorial Lecture in Public Law was established in 1994 with donations from the legal profession in Hong Kong in honor of the late Peter Allan, a former Crown Solicitor and commissioner of the Independent Commission Against Corruption. It is an honor to have Professor Fallon here to give this particular lecture. He is, again, the Story Professor of Law at Harvard Law School, Affiliate Professor of Government at Harvard University. Among other things, among other honors, he's a Fellow of the American Academy of Arts and Sciences, a member of the American Law Institute, a two-time recipient of Harvard Law School Sachs-Freund Award for Excellence in Teaching. His background, he comes to us by way of Yale undergraduate and Yale Law School, after which he read PPE at Wadham College at Oxford as a Rhodes Scholar. He clerked for Judge J. Skelly Wright of the D.C. Circuit, the United States Court of Appeals for the D.C. Circuit, and Justice Lewis Powell of the United States Supreme Court. He is the author or co-author of the leading texts in several fields of public law, including Hart and Wexler's The Federal Courts and the Federal System, which I believe is the textbook most cited by the U.S. Supreme Court, and it's one that I have a soft spot for, having been taught from that book and using that book myself. It is a phenomenal book. Several versions of a best-selling constitutional law casebook, which is now in its 12th edition. Several books, including The Dynamic Constitution, now in its second edition, which is, I can strongly, heartily recommend it as the best concise introduction to U.S. constitutional law out there. I can recommend it to anyone interested in learning about U.S. constitutional law in a concise, clear, and insightful way. I don't know of any book that offers more bang for the buck per page or is more readable or accessible on the subject, and every student who has taken this recommendation has been glad to have done so. His most recent book is Law and Legitimacy in the Supreme Court, published last year by Harvard University Press. On a personal note, it is especially a pleasure to welcome Professor Fallon, who was my administrative law professor and also supervised me in my first piece of legal research, original legal research, a short piece in the Harvard Law Review on executive provision of judicial decisions. And so I have him to thank or to blame. You have him to thank or to blame for the fact that I'm here in front of you now, I think. That was the thing that snowballed. Professor Fallon will be speaking on the statutory interpretation muddle, which to give a little bit of context here, this is statutory interpretation is one of the things that Professor Fallon is terrific about is the fact that he periodically surveys the state of the discipline and thinks about where the field is going. And one of the directions of growth and expansion that he sees going forward is in the area of statutory interpretation. And so that will be, and particularly incorporating insights from linguistics. So that will be the focus of his talk today. We will have time for, we'll reserve some time for questions. But for now, I hope you'll join me in giving a very warm welcome to Professor Fallon.
So thank you, David, for that very generous introduction. It's a great. I couldn't make it work before. You see, something's happened up there. It's a great pleasure for me. Okay, thank you. Push this button. Okay. So it is a great pleasure for me to be here to deliver this Peter Allan lecture. I'm thrilled to be in this great university, in this beautiful city. I couldn't be more grateful for the warm, generous reception that I've been given thus far. It's a special privilege to have been asked here by my former student, David Law. After many years in law teaching, I've had many students. There are few whose subsequent careers have filled me with more pride than David's. So today I'm going to talk about the statutory interpretation muddle. A lot of what I will be talking about will be coming from U.S. law, but from what I understand about comparative law, the problems that the United States is having with statutory interpretation are similar to problems that are being encountered by other countries where statutory interpretation also has to occur. So in that sense, I hope that what I have to say will be of general interest. I will caution at the beginning that some of what I'm going to say is rather technical. Because it is so technical, I've asked if I could use PowerPoint, and I hope that the PowerPoint slides will help to make clear by giving you an opportunity both to see and to hear what might be more difficult if you were trying to take it in orally alone. So the statutory debates in the United States have been very heated in recent years, questions about how to interpret statutes. But I think to understand these debates and the difficulty that people have about statutory interpretation, it's helpful for a very large number of purposes to distinguish non-contentious cases from contentious cases. So most of the time when people encounter statutes, they don't have any difficulty in understanding what the statutes mean, whether they do or don't apply to particular cases, and so forth. So on the slide, I've got reference to tax codes. If the tax code requires payment of taxes by April 15th, then everybody will understand the taxes have to be paid by April 15th, and there won't be any significant issue of interpretation. If the traffic code says no driving over a certain number of miles per hour on a highway, again, everybody will understand without difficulty. But most of the cases that come to the courts are cases where there is reasonable disagreement about what a statute means, or reasonable uncertainty about what a statute means, and then the question is what a court should do about identifying the meaning of the statute in those cases. So just to give you some examples, I will come back to most of them over the course of the lecture. There is an old famous case called Church of the Holy Trinity against the United States going back to 1885. At issue in that case was a statute that prohibited, quote, importation of foreigners under contract to perform labor or service for any kind in the United States. And the question in the Church of the Holy Trinity case was whether this statute made it a crime for a religious congregation to try to induce someone to come from another country to be a minister to that religious congregation. Another case that's caused much difficulty, created a lot of scholarly commentary, is more recent. It's the case of Smith against the United States from 1993. And the question there was whether a statute that provided enhanced punishment for a crime if the crime involved, quote, using a firearm during and in relation to drug trafficking applied to somebody who had actually traded a gun in order to acquire firearms. So what intuitively, I assume, springs to mind when you think somebody using a gun in connection with drug trafficking is somebody who pulls out a gun and threatens somebody. But here's somebody using a gun by trading it for drugs. And so does that come within the meaning of the statute? And then the third example that I've got on the slide, and we'll come to from time to time during the course of the lecture, is United Steelworkers against Weber from 1979, in which the question was whether a statutory prohibition against, quote, discriminating on the basis of race in a statute that had been enacted principally to end discrimination against racial minorities in the United States, who'd long been discriminated against, should be interpreted to bar minority preferences in hiring, training, and promotion. So this was also easy a minute ago. Yes, okay, so I've got the next slide. So in thinking about how to answer these statutory interpretation questions, in the United States today, I would say that there are three leading theories that people talk about. The first is one that actually has come to be relatively widely rejected and even scorned at by sophisticates, but it's the one that for most people is the most intuitive. And that intuitive approach is one that is sometimes called intentionalism. And the basic idea behind intentionalism is if you want to interpret a statute, you want to figure out what the legislature that enacted the statute intended. So the basic idea is meaning depends on intention. That has come to be rejected by most sophisticates, something that I'll talk about later, based on a belief that it is not possible for multi-member bodies such as legislatures to have intentions in the relevant sense. Legislature may intend to enact a statute, but if you want to know, was the legislature that enacted this statute intending to, for example, bar racial preferences for minorities or to treat trading a gun for drugs as either coming within or not coming within the prohibition against using a gun in connection with drug trafficking, there would be no sensible way to answer the question. If you want to know what my intentions are, then you can inquire into what my intentions are. You can inquire into what my intentions are as I'm talking right now, what I mean my words to communicate, and so forth. But my intentions are intentions in a psychological sense, and it is simply impossible for a legislature made up of hundreds of people all to concur in and be possessing the same psychological intention at the same time. So, as an alternative to reliance on legislative intentions to interpret statutes, the more modern, more sophisticated theories are first textualism, which says that the right way to interpret disputed statutes is to ask, how would a reasonable person, there should be the word person on this slide, how would a reasonable person understand the statutory language based on the meaning of the words in their linguistic context? And then there is a purposivist approach that would ask the question, what purpose could we impute to the legislature that would best explain why Congress enacted a particular statute at a particular time? And you can see the contrast between these approaches probably with any of the examples that I used. But if you think about the Holy Trinity case, that was the case where the statute said no importing someone for purposes of labor or service in the United States. Then on a literal interpretation, just looking at the words, a reasonable person might think, well, the words say, no one shall be imported for purposes of doing labor or service of any kind. A member of the clergy does labor or service, whereas someone taking the purposivist approach would ask the question, well, what were the policy concerns that led Congress to want to enact a statute of this kind? Were they worried about the pouring in of cheap labor, people to do unskilled work in the United States? Would it have been part of the purpose to keep out a distinguished professional, and especially would it have been part of the purpose to keep out a religious minister in a country with a strong tradition of religious freedom? So, against the background of the problem of statutory interpretation and against the background of the debates that have been raging in the United States and I believe elsewhere. My basic thesis in this lecture is going to be that there is no linguistic fact of the matter about disputed statutes' meanings. Lawyers will stand up for both sides and say the statute means A or the statute means B. Judges in majority and dissenting opinions will disagree about what the statute means, and they will claim that they are disagreeing about what the statute means as a matter of what meaning is in ordinary linguistic parlance. My thesis is going to be that claims about linguistic meaning in this sense almost always depend on what I call the model of conversational interpretation. And the model of conversational interpretation is an approach to trying to understand statutes that assume that we, as people interpreting statutes, do and should interpret statutes in the same way as we understand utterances in ordinary conversation. My claim is going to be that the model of conversational interpretation does not fit statutory interpretation because the model of conversational interpretation depends on the fact of there being a speaker with psychological intentions in a context in which to try to figure out what statutory utterances mean, we are crucially concerned with what particular speakers, giving their goals, values, purposes, and so forth, were trying to communicate. That's just absent in the statutory context. The real debate about how to interpret disputed statutes, I'm going to claim, is a normative debate of one or another kind about how it would be best to interpret statutes, with the word best being used in a normative sense rather than in a linguistic sense. And I'm going to argue that a good theory needs to come to grips with how language and what I later in the lecture will call linguistic intuitions should influence but not necessarily control the outcomes of statutory interpretation disputes. So just one more preliminary word, slightly apologetic. The thesis that I'm going to be presenting to you is a complex one with interdisciplinary ambitions. Interdisciplinary in particular in the sense that it draws on work in the philosophy of language. But in drawing on this work in the philosophy of language, my aim is going to be to direct barbs in both of two directions. Some of the barbs are going to be aimed at judges and law professors who I think have not attended sufficiently to how language works. And here I have in mind the very famous American Supreme Court Justice Antonin Scalia and a number of textualists. But I'm also going to be directing some barbs at philosophers of language who I think have thought, upon becoming interested in statutory interpretation, that they could just import into the field of statutory interpretation the theories that they have developed to explain meaning in ordinary conversation. And so the argument is going to unfold as a mix of original, I hope, claims, but also some that are familiar to people who are knowledgeable about the ongoing statutory interpretation debates that can be presented, I think, in terms of 10 numbered points. So up to this point, I've mostly been telling you what I'm going to do, why I think it's worthwhile trying to do it. Now I'm about to give you the argument spread over 10 numbered slides. First numbered point. Debates about statutory interpretation assume that statutes have linguistic meanings discernible through the techniques of ordinary conversational interpretation. So any of the examples with which I began, does labor or service in a statute mean the same thing that it would mean if somebody uttered those words in ordinary conversation? That's the question. But there is an odd way and nearly preliminary question about what it means for something to have meaning in ordinary conversation. And there, in talking about ordinary conversation, philosophers of language distinguish two types of meaning. They distinguish between sentence meaning, which they associate with dictionary definitions, rules of grammar, and so forth, in a way that is associated with what lawyers sometimes have in mind when they talk about plain or literal meaning. But philosophers of language distinguish sentence meaning from utterance meaning, what they call utterance meaning, to emphasize that when we're trying to understand each other in ordinary conversation, we're much more familiarly concerned with the meaning of utterances than we are with the meaning of sentences. The idea being that sentences are, yes, uttered, and they've got their meanings given by dictionary definitions, rules of grammar, and so forth. But when we utter sentences, we're often trying to communicate much more and sometimes much less than the meaning of the sentence would suggest. So here would be an example. Suppose someone says, Alex was a big help. So you could look up the meanings of these words. We can assume that there's somebody named Alex. We can identify what was means, what a means, what big means, what help means. But that won't tell us very much. Is uttered in ordinary conversation the claim that Alex, this assertion that Alex was a big help, would ordinarily call to mind a specific person named Alex. If somebody's uttering this sentence in ordinary conversation, it's probably in a context in which there is understanding between the speaker and the listeners about what it was that Alex was expected to be helping with, about what it is that Alex would have done that would have been helpful, and so forth. And you may say, well, that's ordinary conversation, but it can't be that statutory interpretation is much concerned with utterance meaning. But take this example. Imagine there's a statute that says that the president shall have the power to appoint members of the board. So sentence meaning, the sentence meaning won't tell us anything about which president we're talking about. Are we talking about the president of the United States? Are we talking about the president of a corporation? It won't tell us what board we're talking about, and it won't tell us anything about who are likely candidates to be members of the board in terms of what members of the board are supposed to do. All of those things crucial to understanding an utterance or to understanding the formulation in a statute that says the president shall have the power to appoint members of the board depend on what philosophers of language call pragmatic enrichment. And pragmatic enrichment is simply the process by which those of us who were competent users of language, as I assume we all are here, draw inferences in context that help us to understand what people are saying in a way that would not be evident to somebody who only knew dictionary meanings and the rules of grammar. We don't even think about it this way, but dictionary definitions and rules of grammar take us only a small, small fraction of the way toward being able to communicate with each other successfully. So against this background, I think it's crucial to understand that in statutory debates, all theories of statutory interpretation associate statutes' linguistic meanings with their utterance meaning, namely their meaning in context, more something like the way a reasonable person would understand the utterance or the statute in light of all those background elements of context that make it possible for us to understand ourselves in a way that is far broader and richer than a dictionary and a grammar book could communicate to us. So then now numbered point 2, in conversational interpretation of utterances depends on speakers' communicative intentions. And so if I say Alex was a big help, if you hear me say Alex is a big help, you know something about me, you know something about Alex, you know something about the context where I was hoping to get Alex's help. If I say Alex was a big help, that sentence may communicate a very great deal about what Alex did and about what Alex was helpful with. But, and this is crucial, I think, about the relevance of speakers' intentions in ordinary conversation, the way we understand utterances in ordinary conversation, I might say that sarcastically. Somebody say, was Alex at your house? And I say, oh, Alex was a big help, meaning Alex was in the way about everything that I was trying to communicate, was trying to accomplish. And so understanding the way that sentences can be uttered ironically as well as literally helps us, I think, understand the crucial importance of speakers' intentions to the meaning of utterances in ordinary conversation. And then if you say, well, what's the state-of-the-art theory among philosophers of language, then philosophers of language would all agree, nearly all agree, that speakers' intentions are crucial. They would differ about exactly how speakers' intentions matter to utterance meaning. The relevance could be either direct. There are some philosophers of language who would equate the meaning of my utterances with what I psychologically am attempting to communicate. There are others, probably more common among sophisticated philosophers of language today, to say that the meaning of an utterance depends on what a reasonable listener would understand the speaker's intending to communicate. But either way, speakers' communicative intentions are necessary to get from sentence or literal meaning to utterance meaning via pragmatic enrichment. And again, when we were talking about the meaning of statutes, we are concerned with something like utterance meaning because we're concerned with pragmatic enrichment that gets us beyond the bare literal meaning of the words to what they mean in context. So then the question becomes, if the model of conversational meaning depends on speakers' intentions, what are the relevant intentions in the case of a statute enacted by a legislature? So here, regarding statutes, textualists and purposivists agree that there is no speaker with communicative intentions in the same way as speakers in ordinary conversation. Textualists sometimes say that the legislature is a they, not an it. We talk about the legislature as if it were unitary, but actually the legislature is comprised of many, many members who may be thinking different things, hoping that they would have the opportunity to communicate different things, and so forth. So then, I want to say, without a speaker with intentions, we cannot interpret statutes in the same way as we interpret conversational utterances. Having said that, I want to offer one partial qualification. It's actually a important partial qualification, and it has to do with those non-contentious or easy cases with which I began. Sometimes, looking at a statute, it is possible to think that any person, any entity wanting to utter that form of words must necessarily have had some minimal intention, by which I mean the most minimal intention that it would need to be imputed in order to explain why somebody might intelligibly have uttered the sentence or written the statute in a particular context. So if you read a statute that says taxes are due by April 15th, it just seems to be the minimal intention. Anybody promulgating that statute must have intended it to have something to do with a requirement that taxes be paid by April 15th. But the non-contentious cases are neither here nor there with respect to the disputes that divide theorists about statutory interpretation and that judges divide over in particular disputed cases. And so what to do with those cases, given agreement that the legislature is not a speaker with the kind of psychological communicative intent that individual speakers are in ordinary conversation. And here, I would think totally counterintuitively to anybody who was not a lawyer, wasn't somehow steeped in these debates and taken their way of proceeding. For example, for granted, both textualists and purposivists, having recognized that there is no speaker with a psychological intent in the case of statutes, proceed along the lines of saying, well, let's somehow invent a substitute for speakers' intentions. So, proceeding by way of inventions, what do textualists and purposivists do? Textualists say, let's ascribe to the legislature an objective intent or intention defined as what a reasonable person would assume a speaker's intentions to be. For example, if a speaker wanted to say, I think it should be a crime for somebody to use a firearm in connection with drug trafficking. Purposivists say, I think in the absence of actual psychological intentions, we should look at the statute as enacted in its context and say, what would be the purposes? They wouldn't necessarily have to be anybody's purposes in particular, but what would be the purposes that would best explain why a rational legislature might have wanted to enact a statute of a particular kind at a particular time. At which point I want to say the rescue attempts to invent a substitute for the legislature's intent lead to a muddle. And they lead to a muddle because how to invent legislative intent or purpose is a normative, not a linguistic question. Ascribed meanings based on invented intentions will be invented meanings, not linguistic meanings. The real disagreement between textualists and purposivists, I think, if the debate is to be intelligible at all, has to be understood as one that is fundamentally normative rather than linguistic. But then, if that's right, what exactly is the nature of the normative disagreement between textualists and purposivists? So then I want to say the underlying disagreement involves a disagreement about legitimacy or the foundations of legitimacy in law and adjudication. Sometimes we ascribe intentions to people without endorsing them. But when judges ascribe meaning-determining intentions to the legislature, or meaning determining purposes to the legislature, they do so for purposes of invoking the coercive power of the state. On which side will the coercive power of the state be invoked in a private dispute? In the Holy Trinity case, can somebody be sent to jail for trying to entice a minister to come to the United States from another country? In Smith against the United States, can Smith be sent to jail for trading a gun for a longer period of time than he would have been otherwise, for trading a gun in a drug crime? So the coercive power of the state is at stake, and how judges should invoke the coercive power of the state, I want to say, is partly a moral question involving legitimacy. Now, legitimacy is a slippery word. It can mean different things to different people in different contexts. But as I use the term, I mean the term legitimacy to be defined as involving respect-worthiness or entitlement to obedience. With the legitimacy question in the context of statutory interpretation essentially being the question, how should statutes be interpreted such that interpretive decisions deserve respect or obedience? And if that is the legitimacy question, and this is what the fight is about, how should these statutes be interpreted such that as thus interpreted, they deserve respect or obedience, then I think, recognize it or not, purposivists and textualists are appealing to different potential sources of legitimacy. So just remember where I am. I'm assuming that a statute that says it's a crime, criminal punishments should be enhanced for somebody who uses a gun in the context of a drug crime does not have a linguistic meaning establishing clearly, certainly, that it either does or does not apply to the exchange of a gun for drugs in a situation in which it's also easy to imagine that what this statute refers to is somebody who uses a gun in the way that people more ordinarily use guns in the context of drug crimes, which is to pull the gun on somebody and threaten the person. So in this kind of situation, I think what purposivists are assuming is that the best way to achieve legitimacy in statutory interpretation is to impute to the legislature purposes that yield good, just, or reasonable outcomes, with, in some sense, the underlying premise being that good government, insofar as it can be produced, is a source of interpretive legitimacy, a source of judicial legitimacy. Textualists, on the other hand, are very afraid that when judges get to impute purposes to the legislature with the aim of achieving good and just outcomes, judges will be usurping power that properly belongs to the legislature. They will be imposing their values in a way that ought to be suspect from the perspective of democratic theory. And so textualists want to say we should focus on the words of the statute rather than try to figure out what the purposes are that may have lain behind them, because it's only by assuring legislatures that their words matter, their word choices matter, that we make it possible for democratically accountable institutions to govern, including making the law that is applied through statutory interpretation in a democratically appropriate way. So then, I know I rushed through the last sentence as if maybe I didn't have a whole lot of conviction behind what I was saying because of what I want to say on the next slide, which is that I think that textualism, which has recently dominated interpretation debates in the United States, is too undeveloped for principled application. And I think it's too undeveloped because the abstract idea of textualism, which is try to figure out what a reasonable person would understand a statute as meaning is in its context, tells us nothing about what a reasonable person would think, and tells us nothing about how to impute purportedly objective thoughts to this reasonable person, or nothing about how the reasonable person would go about imputing supposedly objective intentions to the legislature. So come back to the Smith case. The Smith case was a case a lot of people divided about. To tell us that we are supposed to interpret Smith in light of what a reasonable person would think is really not to say anything very helpful at all. And among the reasons it's not to tell us anything very helpful at all is if we were back in the conversational context, what a reasonable person puzzled about the application of a sentence that some conversational partner had just uttered would want to know is, what did the speaker intend? But we're denied that resource in the case of the legislature. And again, the only point I want to make here is that given this gap separating the model of conversational interpretation from what goes on in the statutory interpretation, to say, what would a reasonable person think, if you mean what would a reasonable person think in the conversational context, in that conversational context, the reasonable person would think, I want to know what the speaker intended, but we're in a muddle. We've got nowhere. Because textualism is too undeveloped and thus leads to unprincipled application, and there's an analogous indeterminacy in purposivism. So what I want to say then is that we're in a muddled situation of pretending to base claims about statutes' linguistic meanings on inventions, objective intent for textualists or purposes for purposivists that are too indeterminate to ensure either substantively or democratically respect-worthy results. We're playing a game that can't be played successfully. So at this point, I'd say, well, let's begin a reconstructive project. And seeking legitimacy, I would say at the outset of this reconstructive project, we need to be realistic about legislatures' capacities. And in saying we need to be realistic about legislatures' capacities, what I mean is it's all too easy to say that legislatures ought to write clearer statutes. But in an era in which many statutes are very long, complicated, go on for tens or even hundreds of pages, the idea that a legislature of hundreds of members is going to be able collectively to work through the implications of every line is just to engage in totally wishful thinking. And again, if we were in the conversational context, if somebody utters something rather casually, and we're not sure what this casual utterance would seem to mean, we want to rely on the person's intentions. We know a lot about the person. We know what the person thinks, what the person values, what the person was trying to accomplish. A single legislature about whom we knew a great deal in the legislator about whom we knew a great deal in the psychological sense might be able to legislate clearly. But no, given what legislatures are, multi-member bodies incapable of forming clear collective psychological intentions in a situation in which sentence meaning often doesn't tell us what we need to know. In that situation, we just have to expect that there are going to be a number of cases coming to the courts in which courts have to say, the outcome of this case cannot be controlled by a clear linguistic meaning. There is none. So then the challenge is, what are courts to do? What are legislatures to do? And I want to say if legislatures are to be able to legislate successfully, they need assistance from courts in the role of junior partners or helpmates. And the challenge is to figure out how courts can play that role of junior partners or helpmates without usurping the legislative function, without undermining the foundations of legislative supremacy and political democracy. Because once again, nobody wants government by judiciary. So then next step, seeking legitimacy. I think that interpretive theory should distinguish what I want to call well-grounded linguistic judgments from linguistic intuitions. And the point here is rather technical. I'll try to do it in a way that doesn't become hopelessly bogged down. But when philosophers of language work with the model of conversational interpretation, they develop a relatively sophisticated, coherent theory, including specified truth conditions, identifying under what circumstances we could say that A communicated a particular message to B. And so if we want to think again of the case, Alex was a big help within the sophisticated kind of model that philosophers of language ordinarily work with. If I want to say that if what we want to get at is the idea that Alex was a big help to me by typing up a number of footnotes that I had scrawled out in longhand and didn't have time to enter into my own manuscript, something of the kind. The philosopher of language would say the truth conditions for this would be that a reasonable listener would understand me, knowing who I am, what I needed help with, what I was eager to get done. A reasonable listener would understand me, knowing all these things about me, as having used the words that I used with the intention of getting the reasonable listener to come to believe what I wanted the reasonable listener to come to believe. It's all terribly complex, even abstruse, but the idea is that within the way philosophers of language think about these questions, utterances have meanings. We can reach well-grounded linguistic judgments about what utterances really mean as a matter of linguistic fact. But it depends on a lot of things involving knowledge about the speaker. So that's well-grounded linguistic judgments. We can reach them, be confident that we were right, tell other people they were wrong if they don't agree with us, if we know enough about what the speaker was trying to communicate in the context in which the speaker was trying to communicate that. But then I want to say, even absent speakers' intentions, people often have linguistic intuitions that the philosopher's model won't validate. So to use one of the examples that I've been talking about throughout this lecture, think about United States against Smith. Does the phrase use a firearm include use for barter? So I want to say that there is no linguistic fact of the matter, that the philosophers' models about what it takes to arrive at well-grounded linguistic judgments will not answer the question, does use a firearm include using a firearm as an item of trade rather than as a weapon with which to threaten. But nonetheless, if you go out and ask people what does this statute mean, people will have linguistic intuitions. People will think, I know. People will divide about this question. Anybody who's a law professor and who's taught this question in class will know some students will say, literally use means use for any purpose. When somebody trades, that's using. Other people will say, no, any person who understands the way people ordinarily use the words in English will understand use a firearm means use a firearm in the way that firearms are conventionally used, which is to shoot or to threaten. And so then what I want to say is that although there is no linguistic fact of the matter, which would depend on speakers' intent, broadly shared linguistic intuitions, where they exist, do and should matter to statutory interpretation for reasons involving moral legitimacy. It's not the linguistic fact of the matter that makes them matter. It's that ordinary people should be able to understand their rights and obligations under the law. And if most ordinary people would think, for example, use a firearm means use a firearm as a weapon and not otherwise, then the interpretive result will be more legitimate, making it more possible for ordinary people to understand the law and their rights and obligations if the statutory interpretation conforms with ordinary linguistic, widely shared linguistic intuitions most of the time. I want to say more about this because there are many factors that can contribute to legitimacy. Sometimes those factors will be in conflict. The way most people understand a statute is one factor contributing to legitimacy in interpretation, but not necessarily the only ones. So what I want to say, the last line on this slide, is ordinary normative factors matter too. Other normative factors matter too, but shared intuitions contribute heavily to legitimacy when most people's linguistic intuitions converge. But linguistic intuitions should not always control absent facts about meaning, and this is especially true, I want to say, in situations in which there is not widely shared convergence. So now let me put to you two cases. Case one, if there are widespread disparities or uncertainties, then obviously I would say judges need to choose, and they need to choose on legitimacy-making grounds. So here, let's use the Weber case. That's the case prohibiting discrimination on the basis of race. And for these purposes, I want to assume that people's linguistic intuitions will be divided about whether a statute of that kind enacted at a time when the United States was trying to end a long-standing pattern of invidious discrimination against people of color. I want to assume people's linguistic intuitions could be divided because if you look up discriminate in the dictionary, you find that it can refer to either A, all differentiation, or B, only to unjust differentiation. So some people may think it forbids all differentiation, no discrimination on the basis of race, even for purposes of creating minority preferences. Other people's intuitions may be, no, discrimination is a moral term, a term of moral condemnation. It applies only in reference to unjust differentiation, and if affirmative action preferences for previously disadvantaged minorities are just rather than unjust, then the prohibition doesn't apply. And so in that case, if linguistic intuitions diverge, I would say more or less obviously courts would need to choose, and they should choose in light of normative reasons about which would be better or fairer. Is it fairer to prohibit all differentiation on the basis of race, or against a background of long-standing disadvantage of a class of people, is it fairer only to prohibit discriminations that hold down previously disadvantaged groups? Then case two, now suppose that most people's, but not everyone's linguistic intuitions would point to a normatively poor result. So for this purpose, again, I want to use Weber. Let's just assume that most people's intuitions would mean a prohibition against discriminating on the basis of race prohibits all differentiation on the basis of race. It stops not only differentiation designed to harm people of color, but it also prohibits differentiation for the purpose of trying to correct for historical disadvantage. So assume that most people would think that this statute prohibits racial preferences for racial minorities. But I want to insist that is not the clear linguistic meaning of the statute. The statute could mean, depending on what the speaker's intent was, that all that's prohibited is discrimination of an unjust kind. So the meaning of the statute is linguistically ambiguous. Most people say, but my intuitions are, it prohibits all discrimination. In that case, I still say the judge has to make a normative decision. If the judge thinks it would be significantly normatively better, it would contribute more to the overall legitimacy of the legal system, we'd have more respect-worthy results if the law allowed rather than forbade a helping hand to members of traditionally discriminated against groups, then I would say that's what the judge ought to do for legitimacy-based reasons rather than linguistic reasons. Linguistic intuitions count. The fact that I'm assuming now more people's linguistic intuitions line up on one side than on the other side counts against reading the statute as permitting some affirmative action, but it doesn't necessarily count decisively against. The ultimate calculus, I want to say, has to be normative rather than linguistic. So then a number of people will object, but I think the objections that come most readily are objections that don't hold up. Conservative textualists in a case like this will want to say, but that's not what the statute says. The statute says no discriminating on the basis of race. But I want to say, at this point, the textualist is acting in a question-begging way. I, on the previous slide, showed you alternative dictionary definitions, one of which says that discrimination encompasses all differentiation, the other of which says that discrimination only encompasses unjust differentiation. There is no well-grounded linguistic meaning, and in the absence of a well-grounded linguistic meaning, the decision has to be made on normative grounds. Some people will say, but you're trying to moralize in a context where the decision should be, if not linguistic, then surely legal. But then I want to say currently existing legal interpretive norms do not resolve most indeterminacies. We could try to get better legal rules. I am sure that it would be better if we had them, but in the short term, and I think probably in the long term, judges are going to need to muddle through with ad hoc judgments. And so now, last slide, try to pull together what I have said. I think legal interpreters widely misunderstand how language works and how language and the way that we understand language limits congressional clarity in legislating. There frequently is no linguistic fact of the matter about what statutes mean due to the absence of legislative intentions. In the absence of legislative intentions, we need to rethink the role of courts relative to legislatures in light of limits on the capacities of legislatures. We need a better theory of how courts can help legislatures, and my gesture in that direction has been to suggest that courts ought to make it clear to legislatures that linguistic intuitions matter, but that they do not determine everything. More broadly, I think people who care about law need to rethink the relationship of language and law. Law cannot pretend to begin with the linguistic meaning of statutes when, in disputed cases, linguistic meaning is indeterminate. And then finally, the first step, I think, is to recognize, for people who want to reconstruct our law of statutory interpretation on a more sensible basis, is to recognize the muddle of basing claims about statutes' linguistic meaning on inventions. Invent objective legislative, or what we call objective legislative intentions, and then pretend that they determine linguistic outcomes. We won't get anywhere by pretending without remembering that we're pretending. Interpretation needs further resources than pretense, and should not be based on a fallacy that statutes have linguistic meanings that in cases of dispute they simply do not, as a matter of linguistic fact. So with that, I thank you. So,
So we do have time for questions from the audience. I will, Alex and I will keep the cue, but I will kick things off with a question. And if you have a question, please just raise your hand, and one of the two of us will try to catch our eye. In one of your earlier slides, I think there was I don't know if this was a crucial move or not. The question was, in order to legislate successfully, courts need judges and legislatures need courts to help, to be constructive, to be helpmates. Can we talk about statutory interpretation without a theory of what legislation is, what it means to legislate, and what it means to legislate successfully? How much, if any, of this argument turns on a theory of what legislation is? This may be an unfairly large or broad question, but the mental image that comes to mind is if and this sounds very convincing, these statutes they lack determinate linguistic meaning. That sounds right. But then the mental image that comes to mind is the Coke bottle in the Gods Must Be Crazy, falls from the heavens. There's no intention behind it, and so the question is, what does that society find most useful or constructive to do with it? If there really is no theory of what that Coke bottle came from, what it's supposed to do, what we're supposed to do with it. So that may be a bit of a loose question, but do we need a theory of legislation to go with a theory of interpretation?
Yeah, so I suppose that we do, and I haven't thought this out in great detail, but part of what I want to do is to save the legitimacy of political democracy. The difference between statutes and the Coke bottle falling from the sky is that we all understand that statutes are the products of a legislature. We understand the legislature as having legitimate authority to make law. That is, we understand the legislature as having legitimate authority to prescribe authoritatively what will be the consequences of certain actions, whether it's do X or Y or Z and you'll be sent to jail, or follow forms A and B and C and you'll be able to write a valid will. So we want to, we have a situation in which we understand legislatures as being able to prescribe authoritatively what the consequences of action will be. I don't think anything that I have said threatens the capacity of the legislature to prescribe authoritatively what will be the consequences of A or B or C. Save this. There will be a number of cases in which the form of the legislative prescription will be one that lacks determinate linguistic meaning in the way in which we ordinarily think claims of determinate linguistic meaning can be grounded. And we just have to accept that this is a fact of life under political democracies that operate with legislators instead of single-speaker autocrats whose intentions are more transparent to us, and figure out how courts can help legislatures to legislate successfully in a way that would be regarded as successful by the legislatures and by the populace.
So we have, yes, and if you could push the red button next to your microphone, and when it lights up.
Thank you very much, Professor Fallon. It's fabulous to hear the topic of statutory interpretation raised in a forum like this. My name's Theresa Johnson, and I'm the law draftsman here in Hong Kong. So I have together with my colleagues here, we have a very strong interest in today's topic. I guess I come to this from a slightly different perspective, in that when dealing with most laws, they are the statement of policy of the government, and ordinarily they are accompanied by statements about the law. And so we look at things like the extrinsic aids as being something that may be useful in interpreting what a statute says. And I was listening, and you were talking about the sort of linguistic approach and talking about it's what a reasonable person thinks. And I just am interested in your view about how what a reasonable person thinks depends on the context that the reasonable person is thinking in, and the sort of total picture. For example, what a minister has said in introducing a bill, what the documentation that's available in the legislature says about a bill that's enacted. I completely agree with thinking that we can't ascribe intention to the whole of the legislature, but I'm just a little interested in exploring more how what a reasonable person thinks may be guided by those other materials?
Right. So I think that this is a fascinating question, which I thank you for very, very much. And it, to my way of thinking, it is a question about the relationship between law and language in the following sense. If we start on the language side, if we just start on the language side, and we want to know how reasonable people go about understanding what utterances mean, they start with the intentions of the speaker. And I've been insisting that here there are no intentions of the speaker. So then I may be putting words into your mouth, but this is the way I understand what you say, and I am very sympathetic to what I take you to be saying. But that's not the way that it works in law, in legal interpretation. In legal interpretation, everybody understands, should understand, can understand that there is a historical and legal and legislative context in which the words of a statute are enacted. And people who are conversant in the law routinely allude to a number of these factors of context, thinking that the factors of context, legislative history, committee reports, drafters' notes are sometimes included in statutes in some jurisdiction. And all in light of all of these things, we can understand what the statute means. Now, I said, I'm here interested in the relationship between language and law. If we take all of those things into account, I don't think we're talking about linguistic meaning. I think we're talking about legal meaning, which is fine. I'm a lawyer. I have no interest whatsoever in disparaging legal meaning. It's law and legal processes that, at the end of the day, determine the legal effect or non-effect of legal terms. So we're now in the domain of law more than language. And then it's at this point that I am inclined to say, with my emphasis on normativity, in the legal systems within which I am within the legal systems with which I am most familiar, if you took any of those three examples with which I began, no importing anybody for purposes of service or labor, use of a gun in connection with drug trafficking, and no discrimination on the basis of race. Does it apply to affirmative action and not apply to affirmative action? In the jurisdictions of which I know anything, the legal materials would leave room for dispute about all those questions, about the right way to interpret all of those statutes. And so one way to put it would be this. If somebody was a hard positivist, and by a hard positivist I mean somebody whose view of what the law is that there is law so far but only so far as nearly everybody agrees what are the laws, what are the rules that ought to be followed in interpreting a statute. Hard positivism would say that these are questions unresolved by law. And then, if the question's unresolved by law, what ought a judge to do? Well, I said if the question's unresolved by law, then what the judge obviously ought to do is the morally best thing to do. So thus, normativity comes in that way. Now, there are other people who would describe themselves as legal positivists, and they would say, but in cases that otherwise would be indeterminate, the law calls for judges to rely on moral criteria, then I would say judges have to make normative judgments and normative choices. So I think at the end of the day, I agree with very, very, very much of what you said that we have to think about law, and we have to think about how legal sources bear on the proper interpretation of statutes, and not just linguistic or moral ones on the other hand. But I think that the law in its current state in the jurisdictions that I know best is likely to prove indeterminate even after those resources are brought to bear. And I can further tell you that whether all of those resources ought to be brought to bear is very controversial in some jurisdictions. Some jurisdictions prohibiting reliance on legislative history, and reliance on legislative history being very controversial in some jurisdictions where it's just not outright forbidden.
Thank you so much for such a spectacular lecture. Sorry, I'm kind of losing my voice. I have a question about how your theory can be applied to deeply divided societies. I mean, divided in a sense of the basic understanding of moral rules. Earlier you talked about normativity, so it's a relevant question. Are you referring to objectivity? By referring to normativity, are you thinking of achieving, applying your theory to reach some objective normal rules for people to apply and then settle issues that has caused the society to be deeply divided?
Right. So I think the answer to the question is yes, but let me work backward from that. There's something here that's deeply troubling. You put your finger on what is deeply troubling. When we want law, when we want legislatures to enact law, it's because very often people are divided about what ought to be done, what's the appropriate way for a society to be organized, and what we want the law to do is to resolve the doubt, to make a decision once and for all, end the moral disagreement. If you don't like the way the law is, go fight it out at the ballot box the next time lawmakers are being elected. So we want this all the more when societies are divided. And everything that I have been saying is, even in divided societies, judges have to make these normative judgments. And in one way, that's an uncomfortable position to take, but what I want to keep insisting is there is no choice. There is no choice. If there is not a clear linguistic meaning, if there were clear linguistic meanings, they will follow the clear linguistic meaning. But 90% of my lecture was devoted to the proposition that there is no clear linguistic meaning. So that's not a viable answer. The first question was, well, could we maybe find ways to have law, legal rules of interpretation, determine the meaning? Maybe, but there aren't any that do it right now. And so what choice is there other than normative judgment? In some sense, the answer to that question is none. Now, I tried to take a step, or at least a half step, in your direction by saying I thought that widely shared linguistic intuitions ought to count very heavily in the normative calculus. That it's not just what would the judge's personal preference be about who won and who lost, but the judge is also supposed to take account of what do most people think, because if most people think, have linguistic intuitions that one side ought to lose and the other side ought to win, then that counts for legitimacy-related reasons. But at the end, what I want to say is, yes, you've put your finger on the most troubling aspect of what I have been arguing, but the implications of the 90% run-up to that argument about linguistic indeterminacy leave no alternative. Somebody has to decide. Somebody has to decide on normative grounds.
Alex Green.
Yeah, can I just echo what was said before, literally, apparently, and say that was a fascinating lecture. Thank you so much. And as I mentioned earlier to you today, I'm completely on board with the punchline, as it were. And so apologies if my question seems a bit garbled, because I'm having to sort of fight against my own intuitions in order to ask it. And so the first part of it is, does this argument turn on there being no linguistic fact of the matter about what statutes mean, or there being no clear linguistic fact of the matter about what statutes mean? Because I think those are two different things, and it's the difference between indeterminacy and uncertainty, right? And I think that might matter for your opponents in the following way. Obviously, we have no access directly to each other's psychological states, and intentions are psychological states, right? So the way I would typically try to access your intentions in conversation is by eliciting more and more linguistic information from you, right? So if I didn't understand the first sentence, I would ask a clarificatory question and so on. And so typically, I accrue information in a consecutive manner, right? But one of your opponents might say, well, that's an instance of unclear linguistic meaning in conversation. However, obviously that's not possible with a statute, so that's a point on your side, but there might be a way in which we can ascertain more information, not consecutively, but concurrently, by broadening the range of ordinary linguistic analysis. And this is a familiar strategy from that sort of camp. So you don't look at the individual word, you look at the sentence it's in, and then the provision, and then the statute as a whole, and then you might look at other surrounding pieces of legislation that are linguistically similar. You might even look at previous court decisions and so on. So, and the charge would be something like this. Sure, we accept that in many cases there is no clear linguistic meaning, but that is often the case in conversational interpretation as well. There might nonetheless be a fact of the matter, it's just hard to find, and we can ascertain it by looking not by eliciting consecutive requests for information, as in conversation, but through concurrent requests for information, if you like, by looking at a broader range of legal materials. Now, and I suppose this goes to the point of exactly how frequent you think it is that a genuine hard case arises where linguistic meaning really does run out. Because, I mean, I think my own intuitions are like yours, and that's actually far more frequent than people seem to think. But the pushback that I get when I raise this argument anyway, most of the time, is of this nature. No, it's not, because, don't we misunderstand each other in conversation all the time, and that doesn't seem to stop us. So what's different? Can it really be just this difference between concurrent and consecutive information grabbing? Does the order in which we get the information matter, et cetera, et cetera? So,
right. So there's a huge amount there, and having been cautioned by David about the importance of time, I won't be able to respond to all of that. I'll pick up on one small bit, and then respond to what I take to be the most salient point that I think I have to say back, even though it doesn't answer everything you said. With just the sort of an aside, I actually am very much on board with those who say language works well enough for ordinary purposes, including with law. We get a lot of hard cases. I don't know how to quantify them, but most people go through their whole lives dealing with laws and statutes and never needing to be in a court, never being in a situation of doubt about what the law means as applied to them. Here's the phrase that you use that I want to pick up on, because I think it helps get what I most want to say to you. You asked the question in terms of no linguistic meaning or no clear linguistic meaning. Is there no fact of the matter, or is it simply a case of the fact of the matter being hard to find? I think that I hope this doesn't just run off in a side direction. I think that there are often many linguistic facts of the matter, but in the kind facts, plural, many linguistic facts of the matter, but no linguistic fact that ultimately determines meaning in the way that we care about, in the cases that we care about. And so then, is it that there is no fact of the matter, or that it's just hard to find? I think that the reference to truth conditions, under what facts would we want to find in the broadened context that you're describing, such that if we had all of the relevant information, but no speaker's intent, we could say, yes, all these facts are hard to find, but they determine a unique meaning. No, I don't think we know what those truth conditions are. I think we've got a model for well-grounded linguistic meaning in ordinary conversation developed by highly sophisticated philosophers of language, but that model just doesn't work in the statutory interpretation context. And until you fill it out and tell me exactly which facts we would want to know, and in light of which we could say, yes, now, it was hard, but we figured out what the fact of the matter is. Until you can do that, then no, I think I just want to say, no, it's not that it's hard to find the fact of the matter, it's that there's no fact of the matter to be found.
So we'd just like to thank you, Professor Fallon, for coming. This is a small memento of Hong Kong View Law's 50th anniversary, by which we hope you can remember us. Thank you again for coming, and let me just mention again, this is Law and Legitimacy in the Supreme Court, Harvard University Press, Good Faith and Legitimacy in Constitutional Interpretation. If any of that sounds interesting, the book is now available. And thank you again for coming.
Okay, thank you. I was not here to hawk books. I will not forget Hong Kong University or its 50th anniversary, and I'm very grateful to you all for your attention.
Thank you.